I'm Dr. Jonathan Ercanbrack. I'm an academic at SOAS, University of London. I'm coming to grips essentially with contractual governance and the use of technology in relation to that. This presentation represents exactly that. A initial step at coming to grips with some very complex questions, some of which don't really yet have a solution. Religion, by the way, I haven't addressed the role of religion in this, but I'm happy to field questions and I'll give it my 10 cents. Contract ultimately is the formalization of human exchange based on trust. We have legal institutions such as courts, and they instill trust. When we contract, we're contracting often in the so-called shadow of the law. We may not invoke the law, but we know that the law is there, and we go to the law, if we're in a Rechtsstaat, in a system of law and order, to enforce promises. The other ways of doing that are based on reputation, familiarity, and dense social networks, where we can exclude parties from those networks, and that is our means of enforcing contracts. Blockchain is enormously revolutionary, and I'm aware I'm speaking to a room of technologists that have been preaching this for a long time, so please humor me. It's revolutionary because it purports to replace interpersonal trust. Interpersonal trust in human exchange, in contract making. That's a much bigger deal than kind of the gimmicky expression that perhaps it has become, and I think the ramifications are certainly worthy of study. So I'd like to then think about smart contracts. Smart contracts are computer programs that run on the blockchain, principally the Ethereum blockchain, and they self-execute when a set of predetermined terms are met, when conditions are met. And that ensures performance. That's enormously powerful because of the transaction cost savings that are solved. But essentially, from the law's point of view, blockchain using smart contracts records smart contracts into the blockchain. And that makes them nearly immutable. They're very difficult to be revoked. But the role of contract law, ultimately, is to remedy the problems, remedy contractual problems. And the inability to revoke contracts, to rescind contracts, to remedy the problems that have arisen in contractual scenarios is a major problem for the law. And academics, as well as practitioners, have wrung their hands and busied their minds with exactly this scenario, that in fact smart contracts are seeking to avoid the law, maybe not directly, but indirectly by placing emphasis on ex-ante performance, meaning architecting the degree of legal certainty prior to entering into the contract. Now, of course, anybody entering into a contract seeks to architect the degree of legal certainty. You want to make sure that your contract is performed correctly and that you don't wind up in court. But smart contracts make that a necessity. You have to have a perfect contract because the chances are you may not be able to go to court. That's rather difficult. Well, it's obviously, it's the most distinctive and controversial feature of smart contracts as well, for exactly that reason. But it also represents a certain transition in contracting that I think we need to be aware of. Normally, of course, we've created contracts that are based natural language contracts. Now we're dealing with code-based contracts. The ramifications of that are quite serious. When we try to find solutions in contractual problems, we must courts have to interpret the natural language of those contracts. That natural language is abstract and context-based. Rules and principles mean something different depending upon the particular context in which they're expressed. Now, if we're dealing with code, we have to be able to interpret code. That's problematic, one, because we don't have many judges who know how to interpret code. They can't read programming language to begin with, or at least not many. So that's a big issue. But it also signifies another issue, is that how do we determine the intentions of the parties when those intentions are expressed only in code? So we're getting into contractual complications here that are markedly changing the way in which we engage in exchange with social but also tangible legal consequences. So as I mentioned, smart contracts, and the reason why I suppose I'm talking about them, is because of their huge benefits. By excluding the negotiation costs, the monitoring of contracts that one has agreed, but also the dispute resolution costs, having to hire a lawyer, having to go to court. These things become prohibitively expensive, and any businessman would be attracted to the idea of avoiding lawyers altogether. I think the technologists will agree with me in this room. Pardon me. I'm glad I have my notes. 2 seconds, please. One of the big preoccupations of academic thought in this realm is to think of code as being synonymous with law. We've heard that previously. What are we actually talking about there? We're talking about the feasibility of code in so-called cyberspace, of creating a normative framework that replaces or that is autonomous from state law. This is often termed lex cryptographica. It's harking, essentially it's reminiscing on the cryptographic tools that are used in blockchain to ensure consensus, to ensure privacy, pseudonymity. What's the relevance of this? Well, the relevance of thinking of the development of these normative frameworks is to think about the way in which I think the law is changing. The law is changing. I would say the law is being technologized. It's markedly changing our interpretation, but it's also changing before our very eyes. Regulatory networks, regulatory frameworks are being developed. New legal rules and principles are being developed. The entire architecture of law is changing, and code is law, or the lex cryptographica essentially embodies that. But that sort of intellectualizing, if you will, and thinking about the law, the way in which it's changing with respect to technology, is perhaps mostly academic at this point. Because in fact, what we're seeing are disputes that are arising exactly in this realm of smart contracts and digital assets in particular. And those disputes are very frequently focused on interpretation of coded terms. And hypothetical future disputes as well center on those things. Namely, parties may disagree about the meaning of terms in a contract, and that's usually where somebody fails to do something. That's pretty standard. Where the code performs differently to how one or both of the parties had expected, because code actually can do things that wasn't expected. Where it's altered in bad faith, where the code has been hacked, where there's been a system upgrade, and that has changed the performance of code, or where there's been an error or a bug in the code. Well, I'm mostly familiar with English law and less with EU law, but in, let's say, a hypothetical finance realm, most issues in the financial field, most disputes center on contract interpretation, breach of contract, fraud, and negligence. These are the kind of disputes that are arising in this realm and that relate to smart contracts specifically. So I want to pose the question, is litigation, changing gears, is litigation less attractive than arbitration? Litigation has been lamented for being very, very costly, very time-consuming, and increasingly not having the capacity to deal with code-based contracts because of less expertise in the judiciary, though I'm told that that is being remedied. And I have no doubt that various well-developed legal systems are seeking to improve that as we speak. Arbitration, however, and I've defined it here because I'm speaking to a broad audience. I think that you all understand this is a private process of dispute resolution. One of the big pluses of arbitration, beyond choosing your own governing law, which you can do in litigation, is choosing the procedural law. And having the flexibility of choosing the procedural law, and that giving a great deal of flexibility with respect to how a dispute is resolved. There has often been the claim that it has been less costly, less time-intensive. I think that's a little bit less clear. We'll have to ask Steve what he thinks about that. He's the expert in this room on arbitration. And Amal, of course, I don't. But it is put forward, it's argued that in fact smart contracts, that they will rely on arbitration. This will become the preferred mode of dispute resolution. And one of the key empirical findings we're seeing with respect to this is that litigation in practice is being used for about 50 to 60% of disputes. Arbitration is being used for the remainder of those disputes, but it is growing. But one of the reasons why it is in fact being chosen is because of its ability to limit class proceedings. Class action suits in some jurisdictions, such as the United States, are common. In arbitration proceedings, they can be limited, whereas in jurisdictions, that may not be possible. In litigation, it may not be possible, excuse me. As well, arbitration provides an ability for multi-stage dispute resolution, meaning you don't directly go to court, you have negotiation, you have mediation, and then maybe finally arbitration to solve the dispute. So it's a much more layered process. Moreover, it's argued that smart contract disputes are likely to involve evidence about proprietary software and hardware, and the confidential nature of arbitration makes resolving those types of disputes more advantageous, so as not to disclose that proprietary information. And where disputes are technical in nature, parties can agree an arbitration clause that allows them to appoint a technical expert. This ability to appoint a technical expert is crucial, and arbitral tribunals are developing this technical expertise. They're developing, in fact, procedural law that deals specifically with resolving smart contract disputes that gives indications that, in fact, arbitration may, in fact, be the preferred mode of dispute resolution. But I want to talk to you about some of the innovation taking place in arbitration itself. We're seeing in practice that most arbitrations are dealing with usually hybrid smart contracts. and not necessarily only solely code-based contracts, meaning usually that code is giving effect to natural language contracts. These types of disputes are almost inevitably going to be dealt with traditional arbitration, and then this is a well-known story. Solely code-based contracts, however, are likely to give rise or incentivize the development of legal tech that basically that solves the problem itself. And please forgive my my slides, which take for granted your technological knowledge. This is as much for me as it is for you. The multi-signature capability of smart contracts and arbitration, instead of using a single signature, which provides a private key and a public address for sending and receiving cryptocurrency, essentially introduces multiple signatures. And I suppose that this is fairly standard. The interesting part of this M of N capacity to introduce a third party ends up being quite important for purposes of dispute resolution. If you introduce a third party, you can introduce an adjudicator. And the technology potentially, the smart contract technology, because of its emphasis on the ex-ante performance, requires you to implement then a clause which then commits the party to arbitrating, commits both parties to arbitrating if a conflict arises. The idea essentially is that the procedural and substantive law to regulate any potential dispute as well could be contracted, could be agreed at the outset, allowing more complex disputes to be resolved with the multi-signature dispute resolution capacity. At present, it's rather straightforward. When no dispute arises, parties can just release the payment and then that's transferred to the recipient without adjudicator involvement. But when a dispute arises, the adjudicator would be asked to determine whether bitcoins should be transferred to the recipient or given back. There are some fairly straightforward prompts. If the dispute arises and something has gone wrong, transfer Ethereum to such and such account. That's a fairly simple set of questions at present with respect to contractual issues. I don't see any capacity or any empirical research which has looked at the complicated scenarios that arise in contractual disputes to determine, how could damages for the expectation interest be awarded? How are various scenarios interpreted and then remedied by the multi-sig capacity? So this is very much a work in progress. It seems much more applicable to consumer contracts. Consumer contracts are going to be quite simple transactions, and the reticence of consumers to engage directly with the law makes this type of feature perhaps more feasible, because you avoid the costs of going to court, and instead, and you do not have the capacity to challenge a big corporate behemoth with whom you're contracting, and instead then you use this capacity to solve a problem and get your money back. And in fact, of course, this is happening with ADR. This provides a decentralized alternative. It's happening on the blockchain that does not have a third-party intermediary off the chain. So that is a marked difference. We would say from a perspective in terms of understanding the nature of this dispute resolution mechanism, it has enforcement jurisdiction. It is a normative system that has the capacity to enforce the contracts that have been concluded according to it. I want to provide some final considerations and just consider some practicalities of a multi-sig award. Now, there's a lot of innovation taking place in arbitration beyond the multi-sig. There's so-called Claros Court and other online courts that are worthy of study. It's a discussion perhaps we can have beyond this presentation. But I'd like to look specifically at enforcing a multi-sig award. Let's look in the future and think that, in fact, this system of dispute resolution develops the capacity to resolve more complex disputes. Well, under the New York Convention, a multi-sig award would have to be deemed a duly authenticated original award. Authenticated means basically the process of confirming authenticity of the arbitrator's signature. Well, an arbitrator's signature in many jurisdictions has to be in writing, and some jurisdictions will insist on that being in formal writing. But the raw transaction data of a multi-sig transaction can, in fact, represent a final and binding award in jurisdictions such as the UK or Switzerland, where an electronic signature can be given for an arbitral award. This is one interpretation. On the contrary, in civil law jurisdictions, multi-sig transactions may not be viewed as final and binding for exactly that reason, that an arbitral award must be in writing and not in electronic form. It's important because if these awards are not recognized, they can be challenged in court, in any court with a competent jurisdiction. It's important to note as well that the consent to arbitrate is important in any scenario. When dealing with smart contracts, it may not be that two parties themselves are interacting to agree a contract, but in fact the machines are agreeing the contract. So the code has been placed on the blockchain and the machines are agreeing the contract. If that's the case, the consent to arbitrate is very much unclear whether or not that has been satisfied. And it's always important to check whether or not the law of the chosen seat renders the contract unlawful. Of course, one of the big debates has been whether or not a smart contract in and of itself is a legal and binding contract. In most cases, that has been affirmed that a smart contract can be seen as a legal and valid contract, but some jurisdictions may not see it as such. That is the end of my reminiscences about smart contracts. Thank you.